Then let's turn to whoops, we're not there yet, to any key takeaways. We kind of go down the,
Sure.
or start from Max, I guess.
Sure,
I'll-
of course. So 2 key takeaways on consideration. First of all, to the extent that you are having employees, you're an employer, you're having employees who are existing employees sign non-competes, be thoughtful about the fair and reasonable consideration that you need to provide to an employee, and be considering what a court might think of the adequacy of that consideration, and also what it means to the value of the whole effort to enforce a non-compete. The second takeaway on consideration is to tread very carefully when it comes to incorporating garden leave provisions, and instead think of ways that you might be able to use the other mutually agreed upon consideration alternative to bolster your non-competes.
Max, we'll come back to that.
My view on this is that to cover some of the issues that about what a employee can carry away in terms of the what's general skills, knowledge, and experience, which traditionally has been something that an employee can take. Where the difference between that and specifiable, very specific skills, et cetera. I think that it's important in employment relationships to tell people that there are certain skills that we think that you're getting here that will be protected. And to look at not merely taking non-disclosure agreements that include the complete kitchen sink and everything, but even if you include that, at least emphasize certain areas, because that's where I see the enforceability later on.
So I have 2 takeaways, one kind of philosophical, if I may, and the other specific. The philosophical one, I think, is the having been the bystander as opposed to my fellow panelists being on the Hill and actively involved in the legislative process, is watching it go back and forth, and that competitive interests on the part of those who wanted to keep the ability to sign people to non-competes because they felt the need to protect their information versus those who thought it was inappropriate to stifle entrepreneurship by binding people to those. My philosophical takeaway is whatever you may think of the law, certainly with respect to advising clients, the first question I'm going to ask is, how important is it for you to have a non-compete? And are there other ways, non-solicitations, confidentiality agreements, et cetera, that can accomplish everything you're looking for without all of the trappings that now come along with your desire for a non-competition agreement? So that's my 30,000-foot philosophical one. The specific takeaway that I think is very important and hasn't been given enough airplay is the disappearing nature of the non-compete for terminations without cause or people who are laid off. I think what that is going to do for us as lawyers is to really kind of put us to the test relative to what we do with that and what we do with that prohibition, and whether there are ways, whether it be in defining cause or having our employer clients being a little harsher in terms of termination of employees, to call a spade, that a termination for cause is a termination for cause, and not in the situation where you have a non-competition agreement, and not take the easy way out and end up losing the protection.
And then just a couple of kind of what might be obvious, but really need to be taken into account, and we've touched on most of these. Have the company sign the agreement, and I agree with Max's point, send a copy of that to the employee. I've had, and I'm sure people who have litigated this thing have had this come up way more often than it ever should, but you wind up with this agreement that's not signed by the company, and what do? Do you tell them to sign it now or not? And the statute arguably requires contemporaneously signing. So impress upon your clients that that is something that they really need to do.
I think Stormy Daniels.
Don't think Stormy Daniels.
Thank you, Steve, for putting that in.
Make sure that you do follow the language of the statute to the T, right? So make sure that you're including that right to counsel. You don't want your clients to lose the enforceability of an agreement because of some technical misstep. Make sure you follow that. Also, and this kind of goes to a little bit on kind of what Rich was just saying in terms of the whether you call it moral or whatever, however you want to approach it. The idea is write these agreements as narrowly as you can to make sure that you just have them covering what needs to be covered. And that means, the restriction itself should be narrow. You get a benefit for that. Under the new law, there are presumptions that go along with that. So hone to the law, and anything less is even better. And that also brings you to the springing non-compete idea, right? If you don't need a non-compete in the first instance, because you're not going to assume that the person moving jobs is going to put your legitimate business interests at risk, then don't have one. Use the springing non-compete idea. Whatever you can do to keep the use of non-competes to the bare minimum, I think is going to make them that much more enforceable for you before a court under the new law.